Prosecutors in the District of Columbia generally follow a formula in terms of how they prosecute DUIs. It's a scary, scary situation for anybody who is stopped by a police officer and is under suspicion of driving under the influence. The instinct of most individuals who are stopped in that situation is to think, I'm just going to be honest. I'm just going to be straight up with the officer. Yes, officer, I did have a couple drinks before I got into the vehicle. I'm going to be cooperative in every way. I'm going to answer every question. I'm going to do everything you ask. Most folks don't realize is that these officers are gathering evidence that they will absolutely use against you later on at trial. So really all you were doing is feeding them a means to make it easier for the government to convict you later on at trial. If the officer asks if they had anything to drink, simply decline to answer. You have a Fifth Amendment right not to answer any questions from an officer at all, at any time. If they ask you to perform field sobriety tests, I would politely decline to perform field sobriety tests. The results of those tests will be used against you at trial. In the District of Columbia, if you are offered chemical testing in the form of a breath test or a urine test, I would decline testing. There are mandatory minimum jail statutes where if you submit to a chemical test and that test is above a certain limit and you are convicted on that score, you will go to jail for a minimum of 5 days. The question you're really asking is, after I'm arrested, do I want to give them more evidence or less evidence to use against me?